May it please the court, my name is Angela Nguyen, and along with my co-counsel Brian Kang, we represent the respondents in today's case, Janice Madrid and Richard Williamson. The issue presented to the court is whether an unsuccessful attempt to detain a suspect by the use of physical force is a seizure within the meaning of the Fourth Amendment, or must a physical force be successful in detaining a suspect to constitute a seizure. To prove that physical force must be present, we will be stating 3 points. 1. The 10th Circuit was correct in concluding that the petitioner was not seized for the purposes of the Fourth Amendment. 2. The outcome of this case should not follow the dicta set in Hadari D. And 3. Even if this court finds that there was a seizure, it must find that the seizure to be unreasonable in order for a Fourth Amendment violation to occur.
To address the first point, the Tenth Circuit was correct in concluding that petitioner was not seized for purposes of the Fourth Amendment, and by using the test found in Mendenhall, the petitioner was not seized. The use of the Fourth Amendment dates back to 1776 with the Massachusetts Declaration of Rights stating every subject has a right to be secure from all unreasonable searches and seizures of his person, his houses, his papers, and all his possessions. The Fourth Amendment protects against both unreasonable searches and unreasonable seizures. Past Supreme Court cases have dealt with the extent of what a seizure is, with Skinner v. Rye Labor Executives, holding that not every governmental interference with an individual's freedom of movement raises such constitutional concerns that there is a seizure of the person. The interaction between police and citizens does not always include a seizure. Terry v. Ohio. A seizure occurs only when the officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen. A seizure requires control rather than a mere touch contact, and otherwise it may be an arrest. The analysis of a seizure has also been formed into a test called the Mendenhall test in United States v. Mendenhall. The Mendenhall test provides that the police can be said to have seized an individual only if, in view of the totality of the circumstances, a reasonable person would have believed that they were not free to leave. This test was widely used in future cases, most notably in California v. Hadari D., and provided a basis for determining when an individual has been seized in a certain incident. This test also takes into account the setting an individual is put in, as described in Chesterman. The Tenth Circuit has successfully followed what has been held in Mendenhall. In the case presented, the petitioner's movement was never restrained, and the petitioner was able to leave the situation as the police did not have absolute control over the petitioner. Furthermore, the petitioner was able to leave the scene as she fled with another vehicle, later being found a day later. The Tenth Circuit looked to its prior cases in Brooks v. Gainsall and found that the officer's use of force against petitioner failed to control her ability to evade capture or control. Despite the respondent's attempt to stop the vehicle heading towards them, the respondent's gunshots did not stop or seize the petitioner. The petitioner was successful in escaping after being shot twice, and the respondents never restrained the liberty of the petitioner. Even after being shot, the petitioner was able to steal a vehicle that was left running and successfully drove herself to Grants, New Mexico, driving approximately 75 miles in distance. She was then able to go to a hospital where she identified herself as Johanna Ray C. Olgan. Considering the totality of the circumstances and the petitioner's testimony on the events that occurred on July 15, 2014, the petitioner felt free to leave the scene and was not restrained by the respondents. Petitioner did not stop after she was shot and therefore was not seized. Furthermore,
Counsel,
yes,
uh,
ma'am.
at what point does a police officer affect the seizure for purposes of the Fourth Amendment?
Yes, Your Honor. As found in Mendenhall, United States v. Mendenhall, a person is seized when when their freedom and liberty is restrained and restricted. An arrest is different from a seizure. With an arrest, it may be a police officer or law enforcement placing their hands on the suspect, but a seizure is different in this case because the law enforcement or police must have complete control or must take the freedom and liberty of the suspect. Furthermore, the respondents clearly identified them as police officers, and it was reasonable for the officers to respond with gunfire when petitioner drove toward them with their vehicle. Respondents were dressed in tactical gear with police badges that clearly identified them as police. The gunshots were fired as self-defense from the respondents as from the respondents as the car from the petitioner was heading towards them, and they felt that they were in danger of being ran over. The petitioner was never seized as she was able to flee from the scene and was able to move to a different city after her encounter with the officers.
Additionally, a seizure requires the acquisition of control. For a seizure to successfully occur, there must be an acquisition of control from law enforcement. The person's liberty must be restrained to where a reasonable person would believe that they could not leave as pursuant to Terry v. Ohio. When a person is seized by law enforcement, they are entitled to challenge the government's action under the Fourth Amendment. Additionally, under this analysis, a seizure occurs only if the suspect actually submits to the police officer's use of force or assertion of authority, and mere physical contact by the officer is not enough to effectuate the seizure, as set in Brennan v. California and also seen in United States v. Smith. In Brower v. County of Inyo, this court held that a Fourth Amendment seizure does not occur whenever there is a governmentally caused termination of an individual's freedom of movement, but only when there is a governmental termination of freedom of movement. In Brower, the petitioner's descendant, William James Caldwell, was killed when the stolen car he was driving crashed into a police roadblock. He had been driving at high speeds in an effort to elude the police when he crashed into a police roadblock created by an 18-wheel truck. These trucks were placed across both lanes of a highway and behind a blind curve so that Caldwell could not see it as he approached. The Ninth Circuit affirmed the dismissal of the petitioner's Fourth Amendment claim on the basis that no seizure had occurred. However, in Brower, the Supreme Court reversed the Ninth Circuit and analyzed the seizure issue before this court with Justice Scalia, noting that a roadblock is not just a significant show of authority to induce a voluntary stop, but it is designed to produce a stop by physical impact if voluntary compliance does not occur. Therefore, the court held that this was in fact a seizure, and that the Fourth Amendment was violated as the police intentionally acquired physical control of a person or possessions. Following what has been set in Brower of a seizure requiring an intentional acquisition of physical control, the case presented today had no seizure. The respondents never gained control of the petitioner, and although gunshots were fired, it did not stop the petitioner from driving, and thus the respondents never seized Ms. Torres or the vehicle she was driving. Additionally, by following the precedent set by Justice Scalia on the roadblocks having a purpose of inducing a voluntary stop, the method used by the respondents, which were gunshots, did not require direct contact and is disproportionate to the method that was used in Brower. Therefore, the petitioner here was not seized under the Brower standard.
To address the second point, the outcome of this case should not follow the common law of arrest in Hadari D. For nearly 30 years, California v. Hadari D has provided a clear and administrable rule to determine when physical contact between an officer and a citizen implicated the Fourth Amendment. However, the common law rule, suggesting that an unsuccessful use of force is nonetheless an arrest, is inapplicable to the case presented.
Counsel, what was a common law arrest?
Your Honor, in Hodari D, it held that a common arrest is when an officer affects a person whom he has authority to arrest by laying his hand to that person. And Your Honor, the common law of arrest described in Hodari D is said that they may place their hands or they may arrest an individual in a certain situation, but they have not succeeded in stopping or holding them into complete control. First, Hodari D is factually in opposite from this case. In Hodari D, there was a chase after a juvenile fled upon seeing a police officer. The respondent Hodari then tossed away something that looks like a small rock just before the officer tackled him and handcuffed him. The officer retrieved the rock, which turned out to be crack cocaine. The state court held that Hodari was seized when he saw the officer running towards him, even though the officer did not have absolute control over the juvenile's movements. However, this court disagreed. Analyzing the recitation of common law principles on which petitioner Torres heavily relies, she contends that the word seizure readily bears the meaning of a laying on of hands or application of physical force to restrain movement, even when it is ultimately unsuccessful. In the case of Hodari, the seizure did not occur until the officers actually tackled the respondent. Hodari D has made it clear that merely to grasp or apply physical force does not constitute a seizure, but rather when the law enforcement actually brings an object within physical control. Following the standards set in California v. Hodari D, the petitioner Torres was not seized.
Counsel, did California v. Hodari D hold that the Fourth Amendment encompassed the common law definition of arrest?
Yes, Your Honor. California v. Hodari did in fact did in fact use common law of arrest in this case because they have found that for Hodari there was not a seizure as she was not deprived of her freedom and liberty, and because her movements were not restrained, but she was arrested because the officers did arrest her and did place their hands to get the evidence they needed for that Hodari case.
Your Honor, to continue my co-counsel's argument on Hodari D, the evaluation of the court in Hodari D must be read in context and in its entirety. When facially looking at Hodari D, the court may be inclined to find that a seizure occurred when an officer slightly touches an individual. However, Hodari D must be read in context for it to be applied to this case. Additionally, it is essential to look at Hodari D in its entirety as it contains dicta that should not be confused with its holding. When interpreting Hodari D in its entirety, the court makes a clear distinction between an arrest and a seizure. The Supreme Court in Hodari D held that a Fourth Amendment seizure requires some sort of physical force with lawful authority or submission to an assertion of authority. In this case, the two police officers were clearly wearing jackets with the word police on it, and moreover, Hodari had not been touched when he discarded the cocaine and had not submitted to authority because he was still attempting to escape. Therefore, the court held that there was no seizure and that it was merely an arrest. The petitioner Torres takes this court's language out of context and uses dicta from the Hodari case. It is essential that this court looks to what is binding, the holding of the case of what actually happened in Hodari. The cases are very similar in that both suspects were attempting to escape, and with Hodari D holding that there was no seizure as Hodari never submitted to authority, a seizure did not occur with our own case. The only approach that makes sense is that a seizure occurs with submission to authority voluntarily or involuntarily. Since the petitioner was able to escape and was able to drive to a different city, a seizure did not happen because she did not stop.
Additionally, the language used by the petitioner in Hodari D is again dicta. The petitioner relies heavily on dicta from Hodari D that references common law principles. The definition of seizure has been clearly identified through many different cases, stating that a seizure occurs whenever law enforcement restrains the liberty of a citizen, Graham v. Connor. Hodari did not look to overturn the holding in Brower or Graham, but instead added on to the meaning of seizure. The holding of Hodari D was limited to the proposition that a show of authority coupled with submission to that authority constituted an arrest. As the holding is always binding, the holding of the case is what is essential, and however, as the petitioner uses dicta claiming seizure bearing the meaning of an application of a physical force to restrain movements, it is not applicable in this instant case. The totality of the circumstances must be evaluated, and thus the common law in Hodari D brought up by the petitioner is not relevant nor is it binding.
To move to our third and final point, an excessive force claim must be proven to prove an unreasonable seizure. Through the
Counsel,
original, yes, Your Honor.
How should the original public meaning of the Fourth Amendment affect the analysis in this case?
Your Honor, through the original meaning of the Fourth Amendment, it affects our case by holding that this court must not find only that a seizure took place, but that an unreasonable seizure took place. For what the Constitution forbids is not all searches and seizures, but unreasonable searches and seizures pursuant to Elkins v. United States. This is necessary because to have excessive force, a seizure must have occurred since the excessive force is simply an unreasonable seizure of a person by that force, as said in Reed v. Clow. To successfully prove the excessive force claim and eventually prove that there was an unreasonable seizure, all four prongs of the Johnson v. Glick test must be considered. If even one prong is disproved, the claim is unsuccessful. An excessive force claim can arise in the context of an arrest or an investigatory stop of a free citizen, and the majority endorsed that the four-factor test is generally applicable to all excessive force claims. Additionally, the excessive force must be found to be objectively reasonable through analysis in light of the facts and circumstances, not in 2020 hindsight.
When viewing this case, all four prongs of the Johnson v. Glick test should be completely considered. The four prongs include 1. The need for the application of force, 2. The relationship between that need and the amount of force that was used, 3, the extent of the injury inflicted, and 4, whether the force was applied in a good faith effort to maintain and restore discipline or maliciously and sadistically for the very purpose of causing harm. Focus turns to the fourth prong in deciding the intent of the application of force. Both police officers were forced to make a reasonable split-second decision in order to protect themselves and others that would possibly be affected by the petitioner's actions. They saw a clear threat to society as Torres was being aggressive and furtive in her movements within the car. At this moment, they believed that they needed to prevent any further threat to themselves and society by acting based on circumstances that are tense, uncertain, and rapidly evolving.
Additionally, excessive force must be proven as objectively unreasonable from the officer's perspective. In determining a
Counsel,
Yes, Your Honor.
was the police officer's shooting of Torres reasonable?
Your Honor, it was not only reasonable, but in determining objective reasonableness from the officer's perspective, this court must look to whether or not it was reasonable, considering that the calculus of reasonableness must embody allowance for the fact that police officers are forced to make split-second judgments. This precedent alone may seem too broad and create a backdoor by allowing police officers to claim all their actions as reasonable split-second judgments, as stated in Graham v. Connor. However, precedents set in that case, along with the precedents set in Tennessee v. Garner, which held that police may not shoot at a fleeing person unless the officer reasonably believes that the individual poses a significant physical danger to the officer or others in community, they were presented with the circumstance that someone under the influence, making aggressive actions and being unresponsive, would be recklessly driving on roads peopled with innocent lives. Without making the decision they did, the officers would have suffered significant damage and injuries, and additionally allow others in the community to be threatened by this danger.
And finally, reasonableness inquiry must be analyzed in light of the facts and circumstances, not in 2020 hindsight. With the analysis of objective reasonableness, this court must consider the circumstances and the position of the officer at the time of the claim, not in 2020 hindsight. There are a myriad of factors and avenues that the officer must consider, but when making the split-second decision, even though it may seem unnecessary in hindsight, the court must note that the same standard of reasonableness at the moment applies. Not every push or shove, even if it may later seem unnecessary in the peace of a judge's chambers, violates the Fourth Amendment. Johnson v. Glick.
In conclusion, a seizure only occurs if the petitioner's liberty is restrained to where a reasonable person would have believed that they were not free to leave. The court must look at the totality of the circumstances as well as the surrounding the petitioner was in, and the respondents made it clear that they were from law enforcement, and as the petitioner did not stop and proceeded to leave the site, her liberty was never restrained as she clearly believed that she was free to leave. By applying the rule of seizure set in United States v. Mendenhall, as well as precedents set from similar seizure cases, this court should find that a seizure did not occur in the case of Ms. Torres. And it is for these reasons that this court should affirm the decision of the 10th Circuit Court of Appeals in all respects and rule in favor of the respondent in today's case, Janice Madrid and Richard Williamson.